Good afternoon, ladies and gentlemen. This afternoon's at the International Convention of Agreement, welcome you all this afternoon. My paper this afternoon is about the case for the descendants of Fiji Indians, an international legal challenge. Much has been stated about mounting a legal challenge against the British government for the atrocity crimes against humanity, and the systematic displacement of a particular race, the Indians of Fiji, for several years. In order to understand such legal challenges, it is important to first examine the Indenture Agreement as a document responsible for the mass transportation of the indentured Indians. Was the Indentured Agreement a contract, and did it have an international legal personality? Was the Indentured Agreement an employment law contract, or was it an immigration contract? The binding nature of Indentured Agreement or the Contractual Agreement is the subject of this research paper, and it investigates the responsibilities, roles, and obligations, if any, of the British Indian government, British Fijian government, the Colonial British Government, and the role played by the state of New South Wales and Queensland in the transportation of Indians to the colony of British Fiji between 1879 and 1916. The key role played by the Colonial Sugar Refining Company, CSR of Australia, Colonial Sugar Refining Company, Fiji and New Zealand Limited, Victorian Sugar Company, the Vancouver Sugar Company, the Australian Steam Navigation Company, Australian National Bank of our National Australia Bank, New South Wales Legislature, New South Wales Government, Queensland Government, Chalmers Brothers Mills, Melbourne Trust Company, South Pacific Sugar Mills Limited, Sir Arthur Gordon, the British Raj from 1878 to 1916, the British Foreign Office, and the British Colonial Government is examined, investigated, and researched. The migration of indentured Indians into Fiji and the systematic torture, unspeakable acts of brutality, castration, beating, severe sexual assaults, and colonial-era abuses are examined and under the United Nations International Criminal Court, and the Roman statute is applied to measure such international legal challenges. Every person born in Fiji between 1879 and 1970 is a British subject, and the research paper further examines both subjective and objective nature of such migration, domicile, and jurisdiction accordingly. The scope of achieving a fair trial within the application of law will require ample academic research arguments and scholarly research as well, which will form critical evidence and provides a fundamental ground to sue the British government, if any. The case of Mau Mau will be examined, and a call for International Court of Justice, International Criminal Court, United Nations Human Rights Council, European Court of Human Rights, the High Court of England and Wales, Supreme Court of Fiji, the High Court of India, the High Court of Australia will be critically analysed for the purpose of such legal processes and proceedings and mounting a legal case at the international stage. In conclusion, I will be examining a demand for public apology by the British Queen, the British government, a compensation fund to be established for the descendants of the indentured Indians in Fiji for the resettlement, education, poverty, welfare, and the assurance of a dual British passport to all descendants of the indentured Indians of Fiji will be argued. In part one of the paper, it is titled Indenture System. The Indenture System had many forms of its application within the British Empire, within the American, French, Dutch, German, and European colonies where the indenture system was introduced. The indenture system was also a system where the employee had a form of a debt, bondage, which was also known as a debt slavery or a bonded laborer, whereby the employee placed himself herself as a security for the repayment of a debt and other obligations. Under the terms of the agreement, within the contractual agreement, the debt was not defined, and the person holding the debt is under the control of the agreement, and freedom is only assumed to be granted upon debt repayment. The laborer is required to repay the debt which is not documented, and the services and the duration of the labor service is documented but is not defined, and the debt bondage passes on from one generation to the next, but the debt is never diminished. Indian Indenture Agreement. Indentured or Indian Indenture System has been in operation from 1826, when the French government drafted the first Indian labor or laborers agreement, which required that each subject was to be presented before a magistrate and make such voluntary declarations under the terms and conditions of the contract or the agreement, which stated that a period of 3 years would apply, and the laborer in the French colony of Reunion were agreed upon by all parties to the contractual agreement. It was further agreed that the laborer would be paid 8 rupees per month, which is equivalent to close to $4 USA a month in today's dollars, and which included rations of food, labor transportation to the colony and back to the place of origin in India. The first Indian indentured laborers were taken from Pondicherry and Karakal in India under the East India Company franchise, which was a business model of trade with India and the British Empire and other colonies to work on sugar and cotton plantations. At the end of slavery, it was quickly realized by the colonial rulers that the indentured or India indentured system was much cheaper than having a slavery system, and Indians could be easily replaced by the slavery or in the slave colonies where the system of agriculture production was being used, and large number of slaves of South African and Pacific Islander heritage were being exploited. Export of Indian laborer. The franchise of the East India Company and its form of governance had facilitated the export of Indian laborers and exploitation under the East India Company's regulation of 1837 from its capital being Calcutta in India. Similar contractual agreements were made as those of French government in 1827, and a system of debt bondage was introduced, and the length of labor service was for 5 years and subject to renewal at the term of the agreement. The agreement further stated that immigrant had to appear before an officer of the government of British India, which with his immigration agent, the engaged Indian would be required to be returned at the end of his or her service to the port of departure as a condition of such indentured agreement. As the indenture system evolved, new legal requirements were systematically introduced, which further required that each laborer were to be provided with standards of diet and such space made available in the vessel for meeting both space standards, and a medical officer was to be aboard the ship. The indenture system was expanded to Madras in 1837. East India Company and the indenture Indian laborers from 1826 to 1858. Under the East India Company, indentured Indians were taken under a contractual agreement to French Reunion from 1826 to 1857, British Mauritius from 1835 to 1857, British Ghana from 1838 to 1857, British Trinidad and Tobago from 1845 to 1857, British Jamaica from 1845 to 1857, British Malaya from 1830 to 1857, and British Grenada from 1856 to 1857. There is still research that needs to be undertaken and determine the actual arrival statistics of Indians in the following colonies and determine under what circumstances and conditions Indians were brought into work in Kenya, Tanzania, Madagascar, Zimbabwe, Zambia, Malawi, Sri Lanka, Cape Colony in South Africa, Windward Islands, Uganda, Belize, Guatemala, Burma, Queensland in Australia, New South Wales in Australia, Zanzibar, St. Cox, Manama, and Matingu. The research could examine and understudy the Kangani system, which was systematically applied to the South Indian origin laborers, and the indentured system applied to all Indians. From 1826, the management of indentured Indians were undertaken by the East India Company until 1858. The rule of East India Company franchise was a rule of governance, military, trade, and systematic control of Indians from 1612. A rule of some 246 years saw the company benefiting from imperial expansions all over India and took effective control and the diminish of the Mughal Empire from India. The East India Company rule lasted till 1858 after the Indian Revolution of 1857. So the Government of India Act 1858 effectively implemented an exchange of executive power from the East India Company franchise to the British government and the direct control of both power and administration of India by the new British Raj. The East India Company itself was formally dissolved by the Act of Parliament in 1874. Let's look at the British Raj and the indentured Indian laborers from 1858 to 1916. Under the British indentured India, the British Raj indentured Indians continued to be transported to the French Reunion from 1858 to 1885, Mauritius from 1858 to 1824, British Guiana from 1859 to 1960, British Trinidad and Tobago from 1858 to 1917, British Jamaica from 1858 to 1916, British Malaya from 1858 to 1920, British Grenada from 1858 to 1960, British St. Lucia from 1859 to 1897, Natal in South Africa from 1816 to 1911, St. Kitts from 1861 to 1890, Nevis from 1874 to 1890, St. Vincent from 1861 to 1884, Dutch Suriname under Treaty of the United Kingdom from 1873 to 1917, British Fiji from 1879 to 1916, and Seychelles Islands from 1898 to 1905. Indians were also taken as slaves from 1767 till 1810. It is estimated that over 12,000 Indians were taken by the French East India Company and later by the French government from 1767 till 1810 to work on Mauritian Islands. The French also took Indian slaves to Seychelles Islands and around 1770, who were mainly of South Indian origins from India, and after the end of slavery, most were absorbed into other colonies and plantations. Indian convicts to the colonies from 1812 to 1873. Historical records suggest that up to 1,500 Indian convicts were taken to work on public works projects in British Singapore from 1812 to 1873, when the system of convict labor was formally abolished in Singapore and the Indian convicts were sent to other colonies to work and were subsequently granted freedom to settle in Singapore instead of being returned back to India. Immigration protector. The British government or the British Raj appointed the immigration protector, which was enacted only in 1881. And by this period, the whole duration of the contractual agreement was reduced from 5 years to 3 years. With relaxed working conditions and new agreements drawn up, and with the laborers having rights to pass on their family names to their children, right to practice and worship the religious practices and freedoms, and housing promised in the contracts, which were in fact small, tiny rooms provided to squeeze and crumble families together. What was documented on the agreement was not provided for, and the reduction in ration and promised wages were deducted for any accumulated debts at the plantation shops, and a day's absence from work meant 2 days of worth of wages were deducted. The institution of immigration protector for the Indian immigrants may have been a central system used by the British colonial rulers, controlling power and influence from a more tolerant and reliable labor source, who often had an attitude of minding its own business. In the hope of colony building process, the indentured Indians were very easily manipulated and adding to the recent three famines in India. It was assumed that such threats and fear-building techniques would work in the colonial rulers' favor, and which indeed worked for many of them. Over a period of 90 years from 1823 till 1916, the Indentured System was the new beginning of the modern-day independent migration system and the modern-day employment law and union of trade unions. Let's look into part 2, Fiji. After some reluctance, the British government acquired the Kingdom of Fiji as a British Crown colony in 1874, as it was predicted and understood that the colony was projected to economically develop and grow. Without much capital and labor, which was at its disposal, the first substantive governor, Sir Arthur Gordon, invited the Colonial Sugar Refining Company of Australia, CSR, to expand its operations in the newly established colony of Fiji. With over 53 years' experience of engaging with indentured Indians, the British colonial rulers knew that there was an abundance of laborers available, which was both cheap, available, tolerant, reliable, hardworking, without any questions or arguments. Our examination is based on the immigration contracts and agreements under which the indentured Indians were brought to work in Fiji from 1879 till the abolishment of the indentured system in 1916, and with the last lot of indentured Indians to finish their contracts or contractual agreements by 1921. Fiji had, from early as 1846, been in contact with the Americans who had visited Fiji for their various economic and commercial interests, as well as the trade of slave servitudes in the South Pacific, as Fiji was deemed as the center of the Pacific. From 1858 till 1867, international attention fell on Fiji as a prize of world cotton rose again, and there were opportunities for both settlers and planters from United Kingdom and Europeans to make the most of Fiji and become the center of attention, as the British government had commissioned an independent commission of inquiry in relation to the ceding of Fiji to Great Britain. It wasn't until 1871 that the British Parliament accepted the to-experiment situation in Fiji, and the first native government of Ratu Seru was established. Then, with its own setbacks, it did not last till 1874, when a further offer of colonial rule was offered to the British Empire, which did not eventuate until 1874 and later into 1875. Many academics, researchers, and historians examined that it was Ratu Seru who laid the foundation of the new Fiji under the colonial rule, and which made it possible for the indentured Indian laborers and the Indian indentured system and the transportation of indentured laborers to Fiji to be introduced. The Agreement system in Fiji. The indentured system, or the Agreement system as commonly known from the term agreement, is often used to reflect a contractual agreement in the English language, whereby one party has had knowledge as to the actual terms and conditions of the clauses, and on the other hand, the other party, the indentured Indians, had no knowledge or understanding of the English language and the contents of the contractual agreement itself. Fiji just became an infant member of the British colony, and only a few years earlier, the natives had started to accept Christianity, while cannibalism was still being practiced in some parts of Fiji by the natives. According to the Fiji Museum, which still has the last remains of Reverend Thomas Baker, who was a Methodist missionary, was killed along with 6 others in the hinterlands of central Vitilevu in 1867, only some 21 years before the Grimitiers were brought to work into Fiji. Indentured system in comparison to Nazi concentrated camps. In the Nazi concentration camps and prison camps in 1944, it was evident that the daily recommended calories were 1,750 per day given to prisoners. In the case of indentured Indians in Fiji, they were given 1,627 calories per day. The modern standards for hard labor and saving prisoners are 3,900 calories per day. The government of India on 30th of August 1878 had duly certified that the government of Fiji had made such laws and other provisions at the Governor General in Council, things sufficient for the protection of natives of India immigrating to the colony of Fiji. This was called Section 24 approval, and as such, the British Fiji government did not enact any new legislation or laws between 1874 and 1891 as per the requirements of the indenture system. Act number 5 of 1837. Since the abolishment of the slavery throughout the British Empire saw the rise of a new type of readily available labor market for the sugar planters in the colonies of Mauritius, which were forced by serious agriculture labor shortages and focus shift to the subcontinent of India. In May of 1837, the Legislative Council in India passed the Act number 15 of 1837, which made Captain F.W. Breach, the Superintendent of Police in Calcutta, renamed Kolkata, responsible for the control of immigration in India. In 1856, the Governor General promulgated an act treating Calcutta Police as a separate organization and the Chief Magistrate of Calcutta was appointed as the first Commissioner of Police under the Calcutta Act and the Calcutta Suburban Police Act, which are still in force till today and which was enacted in 1866. In this paper, an attempt has been made to examine the terms and conditions under which the first Indian laborers were sent to Mauritius under the British Colonial Agreement and a contract of employment leading towards the immigration of indentured Indians. Various amendments were also made to the immigration contract, which included the enactment of Act 21, 1843, Act number 15 of 1842, Act number 13 of 1863, Act number 21 of 1883, respectively, which included immigration protector or protector of immigrations who were to issue licenses to recruiters. All immigrants were required to register for a magistrate at the districts and at the depot before departure. Once the immigrants were sent to the port of embarkment, they were medically examined and inspected by the Surgeon General, and immigrants were declared healthy, willing to migrate, and appropriate arrangements of indenture were applied onto them. The terms of contract. The laborers were to work under a contract for 5 years on a sugar plantation. They were to receive for the labor 5 rupees per month in addition to reasonable rations, clothing, living quarters, and medical care. Their passage to and from India were to be paid 1 rupees allocated for the return passage. A month was to be detained from their pay to provide a return passage for each indentured Indian back to Calcutta. This sum would be returned if the laborer fulfilled their 5-year contract. After the expiry of 5 years, they would either re-engage or return back to India. Part 3 on contracts. Number 1, formation of a contract. It needs to have an intention. With every international contractual agreement, the issue of commercial negotiation and transaction makes it difficult for either party to deal with each other, and the contractual agreement, if any, in an extrajudicial setting. In comparing two different legal systems in force, it is always important to understand how they are at crossroads, and infrequently answers most of the most serious questions of issues in litigation and enforceability between each other. Given the applicability of law in India, Fiji, Great Britain, and Australia being a product of common law, it is important and essential for either small, medium, and large companies such as the Colonial Sugar Refining Company in Australia Limited, and as applicable to individuals such as the indentured Indians, to understand and choose the appropriate law and the governing law for these international transactions during the indentured period. In international transactions, and in particular the application of different legal systems which are at play, the international contract law will only apply to legal rules relating to cross-border agreements at common law. To avoid the need for litigation in international contracts, 3 major issues need to be considered, and which is the question of the application of the relevant law, including the existing of different legal systems, including the common law, civil law, Sharia law, customary law, mixed systems. And in international contracts, there is a general tendency to apply and use the application of English common law. When parties from different countries enter into a contractual agreement, they are governed internationally or by international law unless they agree to abide by the laws of one of the countries. The application of international law is based on the idea of good faith, fair dealings in contracts. These principles are the basis of contractual law in most jurisdictions. Good faith includes fair negotiation, an obligation to cooperate, and good faith when terminating a contract. It also ensures that unfair contracts or deals are not enforced. Since every contract has got an intention, every contract also has an offer. In the absence of consent, subject not being able to be represented or being able to provide with interpretation and translation of the aspects of key elements of international contract law, which includes the provisions that the parties' nationality does not play any role when applying the law, thereby placing all parties on an equal playing field. Rules of contracts are interpreted by what a reasonable person would consider fair and appropriate given the circumstances. International contract law is a branch of private international law within the modern application of international law, which also relates to the cross-border dealings of the individual or the companies. Indentured agreement has been observed to be between both the private international law and the public international law, and the application of customary international law, whereby in the public international law there is a interaction between governments and other states, agencies, and in Fiji's case it was the British Colonial Government, Indian Government, Native Fijian Government, and the British Indian Government, British Raj, and the state of New South Wales, the state of Queensland, and later the Australian Federal Government in 1901. This offers appears very tempting to many prospective immigrants who hoped that an opportunity such as a foreign work had come which would enable them to shake off their poverty back in India. The immigration of indentured Indians, which began under the pretext of fraud, deception, misinformation, lies, systematic torture, abuse of the fundamental human rights, dignity, inhuman treatment at the hands of British colonial administrators, planters, overseers, sardars, CSR, field officers, anyone that would encounter them would treat them as low as a coolie, unskilled, and of seventh class. The 41 years of continuous torture, neglect, and degradation of the treatment as a human being were being tested in Fiji from the first arrivals of indentured Indians on board Leonidas SS sailing ship in 1879 till 1916. Since a contractual agreement needs an intention, it needs an offer, it also needs to be accepted. The provisions of accepting to the indentured agreement, observations have been made as to the nature of acceptance, which includes both the language, the mode, and the spirit of the acceptance. The recruitment process formed the fundamental elements of the issue of supply and demand, designing the process of recruitment, employed the recruitment methods, and the various elements of recruitment proposals. Language of the contract and agreement. The Master and Servants Act of 1867 were laws designed and enacted in relation to the management of employees and employees of the colonies, and which is an extension of the 1823 United Kingdom Act, which describes the regulation of servants, laborers, and work people. It is argued that the legislation had influenced the industrial relations and employment law in the United States of America and in Australia, and by the act which further expanded into the jurisdiction of Canada, New Zealand, and into South Africa. The language of the agreement was to be made in accordance with the Somerset versus Stewart provisions, and the law demanded that the servants were in obedience and in loyalty with their contracted employer, with infringements and of the contract punishments before court of law, often with a jail sentence of hard labor. The United Kingdom Trade Union Act of 1871 was to be implemented, which secured the legal status of trade unions on paper but not implemented in practice. The conduct of the parties. The establishment of direct British government in India under the Government of India Act of 1858 is responsible for the direct control of indentured system in Fiji, which got its core power and authority from the Secretary of State for India, who was a minister in the British government's cabinet and presided over the Indian office in London, and assisted and advised, especially in financial matters, by the Council of India, which consisted initially by 15 Britons, 7 of whom were elected from among the old companies, court of directors. When I say old companies, it is the East India Company, which was being dissolved, and 8 of whom were appointed by the Crown, which was the British government itself. Through some of the British most powerful political leaders, although some of British most powerful political leaders became secretaries of state for India in the later half of 19th century, actual control over the government of India remained in the hands of the British viceroys, who divided their time between Calcutta, Simla, and the control and management of 1,500 Indian civil servants, officials posted on the spot throughout British India. Let's look at Colonial Sugar Refining Company, CSR, and Sir Edward Knox. The European demand for sugar and cotton strongly contributed to the growth of the indentured recruitment from India to British colonies, including Fiji slave trade in the Indian Ocean, which even attracted the United States of America before Fiji was ceded to Great Britain. After taking over Australian Sugar Company in 1842, Sir Edward Knox formed the Colonial Sugar Refining Company in Canterbury in Sydney, Australia. And by 1854, when the Australian Sugar Company went into liquidation, Knox founded the Colonial Sugar Refining Company, Australia Limited, in 1855 from the acquired assets of Australian Sugar Company. By 1857, Knox had formed the Victoria Sugar Company with 50% stake of CSR and the remainder with the Victorian merchants. Between 1872 and 1877, CSR expanded operations in Queensland, Australia, New Zealand, and they produced sugar, golden syrup, and molasses. Under the leadership of Knox, refineries were established in Australian colonies and in New Zealand, and mills were built to crush cane for independent farmers in New South Wales, Queensland, and later expansion into Fiji. Although Colonial Sugar Refining Company, CSR, were directly responsible for the recruitment of indentured Indians into Fiji through a licensed recruitment process in India, from 1879 till 1916, a totally new entity was formed before the end of Indentured System in 1915 to take over the assets of CSR Company. And Knox founded Colonial Sugar Refining Company, Fiji and New Zealand Limited. So here you can see there are two companies. We're talking about CSR now. There are two CSRs being involved. And now we will look into the third CSR that has been systematically formed. New South Wales government's influence. Sir Edward Knox entered the state politics and was a member of the New South Wales Legislative Council from 1856 to 1894 and influenced the New South Wales government in the Australian Sugar Company, Bowen's Sugar Works, Canterbury Sugar Works, Colonial Sugar Refining Company, CSR Properties, Australian Steam Navigation, which was one of the contracted shipping agencies that brought indentured Indians from India to Fiji. And that, if we follow the pattern, it is the P&O of P&O Australia, which is currently operating as a cruise liner in the Australian and in Caribbean and in American waters. Furthermore, Union Bank of Australia, which later merged into the formation of ANZ Bank, Commercial Banking Company, which later became the National Australia Bank, and the Australian Joint Stock Bank, which later became the City Bank of Sydney, and then merged into the Bank of New South Wales. With the influence within the Queensland Government, CSR became the agents for activities operating mills and refineries and acted as agents for Queensland Government. CSR also controlled the export and marketing of all refined sugar from Australia on behalf of the Queensland Government. In part 4, let us look at the foundations of the contractual agreement. The case of Mau Mau is being examined. Considering the case of Mau Mau, Mau Mau is a case where the High Court of Justice in Queen's Bench Division in Great Britain on 21st of July 2011 created history against challenging the British government and getting the crimes of the former British colonial states to be accountable for their various crimes against humanity, war crimes, and the creation of injustice system of the British Empire, whereby the subjects were systematically tortured and made to suffer. This case has opened doors for the indentured Indians and the descendants of the indentured Indians from Fiji to take a direct action against the treatment, inhuman conduct, and degrading work conditions which were projected on the indentured Indians between 1879 and 1920 and from 1921 till 1970. In 2009, 5 Kenyan claimants took the British government through the Foreign Office and the Commonwealth Office to the High Court of England and Wales for both civil actions for damages for personal injuries and for harms suffered in the detention under the British colonial administration in Kenya between 1854 and 1859. The court action had questioned the creation and maintenance of a systematic torture during the period of the emergency in Kenya. The High Court of Justice in the United Kingdom heard 2 separate hearings and determined that the case could proceed to trial, yet it was settled in 2013 by the British government, who continued to accept their lack of responsibility for the harms. Kenya had been a British colony, crown colony, having been procured by the Britain in 1884 and 1885 by the Congress of Berlin. It was formally established as a colony in 1920 and formed part of the British Empire that at the beginning of the 20th century comprised an estimated quota of world's landmass and ruled over 500 subjects. By the end of Second World War, there were three types of British colonies: dominions, settler colonies, which were self-governing, such as Australia, South Africa, New Zealand, and Canada; protocates, which were self-governing under British protection; and crown colonies, which were effectively governed by Britain, which is a state like Fiji. Kenya fell into the last category of autocratic rule, in which the governor appointed by the British Crown reported directly to the colonial office through the secretary of the state for the colonies, which was a similar system employed in Fiji. The restrictive and discriminative policies from land ownership, systematic mental, physical, and emotional torture, immigration policies based on fraud, systematic recruitment on false and deceptive approaches targeted to assist the Colonial Sugar Refining Company, CSR, and the Colonial Sugar Refining Company, CSR, and the Colonial Sugar Refining Company, Fiji and Australia Limited, with a continuous supply of indentured labor. The ruling in this case grants an opportunity to all the descendants of the indentured Indians in Fiji to seek justice against the actions, systematic rule, which was not justified on the indentured Indians and their descendants, which has made them a poorly managed, systematically tortured and subjected to various rules of law since 1879 till 1920, and then from 1921 till 1970, and thereafter from 1971 till 1987. The question of having a nationhood and identity under a good governance and the democracy has been systematically deprived and denied, and it is argued that the British Empire was founded on humanitarian compassion for colonial subjects. At the height of the indenture system, as it was introduced into the colony of Fiji, all indentured Indians were British subjects, as India was a British Raj, and furthermore, every child born in Fiji during the indentured period from 1879 till 1920, and the descendants who were born from 1921 till 1970 were also British subjects, and thereafter all their descendants of the British subjects were British subjects, and as such, the British government has a responsibility, accountability, and as well as a sustainability to maintain the welfare, well-being, and fair dealings with the descendants of their British subjects. While it is strongly argued that Mau Mau case has set the precedent for a legal case for the descendants of indentured Indians of Fiji, colonialism was officially ended as an international practice in the United Nations 1960 General Assembly of the Declaration on the Granting of Independence to Colonial Countries and its people. Apart from the British High Commission in England and Wales, the International Court of Justice, the International Criminal Court, United Nations, Human Rights Council have little to no jurisdiction when the question of individual actions against the past crimes of the British Empire is questioned and argued. On the other hand, the European Court of Human Rights has similar powers to exercise in its discretion and open for trial against the British government and the British Foreign Office or the Commonwealth Office for its past crimes against humanity and against the descendants of indentured Indians could be tried. The Supreme Court of Fiji, the High Court of India, the High Court of Australia could hear the claims only when there is a statement and the enactment of appropriate laws and legislation granting such judicial powers, and appropriate scope for a legal challenge could only be mounted with the presence of a effective legal foundation. The core legal questions that the Mau Mau case has provided in mounting a legal challenge, as the High Court of Justice has decided, where the claimants had argued cases on facts known at the time of the proceedings of systematic torture, and whether the United Kingdom government carries any liabilities for such actions. 5 legal grounds have been established. Number 1, firstly, relying on common law and customary international law. Number 2, that the liabilities of the colonial government transferred to the United Kingdom, UK government when Kenya became independent. Similarly, in Fiji's case, when Fiji became independent in 1970, the powers of the colonial government was transferred to the United Kingdom, UK government after Fiji became an independent nation. Thirdly, the claimants stated that the British government was directly liable for having created a system of torture, ill treatment of detainees as part of common design shared with the colonial government in Kenya. Fourthly, the argument that in July 1957, the British government gave instructions to the colonial government in Kenya to mistreat the detainees. Lastly, the argument that the UK government knew that such abuses were taking place and it could not have prevented the said abuses and still did not do anything to stop it. And furthermore, a further ground established, which is the breach of the colonial powers' duty of care. The Mau Mau case was relied on the specific legal rules and provisions, which is according to Part 3 and Part 24 of the Civil Procedure Rules, Article 11, 14, and 33 of the Limitations Act 1980, British Settlements Act 1887, Foreign Jurisdictions Act 1890, Section 3 of the Emergency Powers Order in Council 1939, Vienna Convention on Succession of States in respect to treaties, succession of states in respect to state property, archives, and debts. Finally, Part 5. Before any claim or action is initiated against the British government, it is important to resolve to some examination of academic and research arguments on the case for the descendants of Indentured Indians of Fiji, and a procedural history is planned out comprehensively. Based on the principles as applied in the Mau Mau case, the case of the descendants for the Fiji Indians will revolve around an action for damages for personal injuries brought by an internationally accredited organization of both repute and standing, such as the Global Agreement Institute, GGI, and the international practice barristers who will be engaged or who have years of experience in respect to claims for torts of assault and battery and negligence, and for which the defendants in this case will be the United Kingdom, and its representative body would seek compensation, which will be the descendants of the Indentured Indians, against the British government, who are liable and responsible for such crimes against the descendants of the Indentured Indians of Fiji. The liabilities and responsibilities are shifted to the United Kingdom as a defendant in this matter, as it was the duty of care which was owed to the descendants of the Indentured Indians in Fiji after independence, and the defendant, being the United Kingdom, had created such situations, both political, economical, and social, which has affected the sustainability of special case of people who were the responsibility of the United Kingdom. That the allegations are well-founded and that the claims would be properly assessed at the time against the perpetrators of their various forms of human rights violations, crimes against humanity, inhuman and vexatious liability, as well as injuries suffered by the descendants of the Indentured Indians in Fiji. In order to mount an international legal challenge against the United Kingdom, the following questions need to be examined. Number one, international legal challenge needs a purpose. It needs to be examined. It needs case laws. It needs critical analysis. It needs legal proceedings. Number two, there is an opportunity for international arbitration. Number three is also an international mediation opportunity that could arise from initiating this matter. Number four, other international dispute resolution mechanisms could be employed. Number one, an open letter to the Queen of England demanding an apology. Number two, a bipartisan approach, an open apology by the British Parliament and accepted by all members of the House of Commons and the Lords. Number three, an open apology by the Fijian Parliament. Number four, an open apology by the Indian Parliament in India. Number five, an open apology by the Australian Parliament, including the Parliaments of New South Wales and the Parliament of Queensland. And number seven, an open apology by the European Union. Furthermore, number five, recognition of all Indians born in Fiji after 1916 to become a British subject. The grant of a dual passport for the descendants of Indentured Indians born in Fiji. The establishment of a compensation fund for the descendants of indentured Indians and their descendants. The international legal remedy would be the compensation by the British government to be assessed by the court or by the international body representing the descendants of the indentured Indians. In conclusion, it is important that all agreement-related organizations, researchers, academics, and organizations, both religious and political, that are products and byproducts of the indentured system in Fiji, such as the Sanatan Dharam Pratinivi Sabha of Fiji, the Arya Samaj of Fiji, the Brahmin Prohit Sabha of Fiji, the 10 India Sangrama Inkra Sangam, Fiji, the Dakshina India Andhra Sangam, Fiji Muslim League, Ahmadiyya Muslim League, Ahmadiyya Anjuman Izat Islam, the Sikh Association of Fiji, Shri Satya Sai Baba Organization of Fiji, Gujarati Association of Fiji, Hare Krishna Movement of Fiji, Fiji Kisan Sangh, Fiji Sugarcane Growers Association, Fiji Labour Party, Fiji National Federation Party, Fiji Football Association, and other organizations and institutions that are products and or byproducts of the indenture system. In conclusion, ladies and gentlemen, without unity, the international legal challenge could not be mounted, and a case for the descendants of Fiji Indians would be a dream only. And it is my humble request that the case of Mau Mau be given due consideration, and there is a legal challenge that could be mounted against the British Crown, the British government, for the benefit of the descendants of the Fiji Indians and the indentured Indians that came from India to Fiji between 1879 till 1921, and the descendants that have stayed back in Fiji from 1921 all the way till today. Thank you very much.